Everyone, I bid you. So the first primary point that I need to put out there is that the offense of parties to offenses is rooted and embedded in section 7 of the criminal code. Another primary point that we need to understand is that in the criminal code, section 7 creates 4 different classes of principal offenders. 4 different classes of principal offenders, which means that if you fall under any of the 4 divisions in section 7 from A to D, you are regarded as a principal offender. What this should tell us is that unlike what is obtainable in the English jurisprudence, where they normally have terms such as principal in the first degree, principal in the second degree, we do not have that there, all these in our code. Our code only recognizes that you are a principal offender if you should fall under any of the 4 categories in section 7. What this also should tell us is that even if all you have done was to assist another person to commit a crime, the fact that you were not the one that committed the crime does not mean that you are not a principal offender. In the eyes of the law, if you assisted someone to commit murder, you are also seen to have committed murder because you are a principal offender according to section 7. And this informed the submission of the learned writer Okonkwo Anaj, when he submitted that the practice of the Nigerian courts in also adopting the English terms such as principal in the first degree, principal in the second degree, aiding and abetting is simply a way of importing into the code that which has not been kept in the code. Another preliminary point to also put out there, and you need to also understand, is that when you look at the criminal code, there are 2 distinct classes of parties. This means that if you are said to have committed a crime under the criminal code, you would either fall under these 2 classes of parties. That is, you are either a principal offender or you are an accessory after the fact. So which means that you either fall under section 7A, B, C, and D, or you are an accessory after the fact. An accessory after the fact is simply someone that did something after a crime has been committed. So you did something to still facilitate the total commission of the particular crime. Then you are an accessory after the fact, which means you would not fall under any of the categories in section 7. And since you do not fall under any of these categories, you are not a principal offender, then you will become an accessory after the fact. So in our criminal code, we have principal offenders, we have accessories after the fact. We do not have principal in the first degree, second degree, third degree, fourth degree, and neither do we have anything like aiding and abetting. Having said this, we shall then proceed to look at the classes of principal offenders. Now, to the first class of principal offender, which can be found in section 7A, that says that every person who actually does the act or makes the omission which constitutes the offense is a principal offender. As earlier remarked, there are 4 different classes of offenders in section 7 of the criminal code. These 4 offenders are regarded as principal offenders. But this first class, that is section 7.1a, deals with the offender who actually does the act or makes the omission. That is the person that is the author of that particular crime, the one that propelled the crime. This person will be the one that shot another to kill the victim. This person will be the one who took the gold from the safe with the intention of stealing it. This person is the one that actually committed that particular crime. And so, if somebody commits a crime, that person that actually commits the crime would be regarded as a principal offender, but under section 7(1)(a). From the look of things, it would appear that this section produces no confusion, because it is straightforward. You did something, then you are liable under section 7(1)(a). However, it is pertinent to put it out there that while this section produces no confusion, it must also be understood that it is not in every circumstance that a person does an act that he will be liable under this section. What I'm trying to say is, the fact that somebody did something, yes, he was the one who committed the offense, it doesn't mean the person will still be liable under section 7(1)(a). And I say this in recognition of the fundamental principle of our criminal justice, which says that before you can hold a man liable, you do not consider only the actus reus, but you also consider the mens rea, that is a mental element. And section 7 does not create a strict liability offense. But when we look at the wordings of section 7(1)(a), we would realize that nowhere was any reference made to the mental element of the offender. It just says every person who actually does the act or makes the omission which constitutes the offense. The question then is section 7(1)(a) a strict liability offense? This cannot be. This can't be when we recognize the purpose of section 24 of the Criminal Code that provides that you cannot hold a man liable without his having the mental element. Thus, we can always import section 24 into section 7. And so, where a man acts without intention, it cannot fall under section 7(1)(a), because by then he would become an innocent agent. And this is reinforced by the decision in the case of R versus Idiong and Umo. In R and Idiong and Umo, the fact is just that Umo was an herbalist and he administered a drug on the deceased, the lady, with the intention of actually helping her to assuage her pains. But apparently it was Idiong that gave him the drug that he administered, because Idiong told him that, oh, this would help her, this would relieve her. Unknown to Umo, the herbalist, Idiong wanted to procure an abortion, and the woman died as a result of this. Both were charged to court. When you look at this case, you find out who committed that act. Not Idiong, no. It was Umo. It was Umo who applied the drug. So ordinarily, Umo would fall under section 7(1)(a). But then, the Supreme Court held that Umo cannot be held liable. And the reason is because he didn't have the mental element. He didn't know, and he was not negligent. But then, what about Idiong? The Supreme Court said Idiong would be liable. The decision of the Supreme Court is correct, but the reasoning of the court seems to be incorrect. Because the court held that Idiong was liable because it is the same as if the unlawful act had been done by the appellant himself. The court was saying that, well, it is as if Idiong had actually been the one that committed the crime. But Okonkwo-Nash, correctly in my opinion, pointed out that the court failed to pay attention to the wordings of the code, because if the court had paid attention to the wordings of the code, its reasoning would have been that Idiong was liable under section 7(1)(d) for procuring the commission of an offense. So, this is it. Then we'll proceed to the next section, section 7(1)(b). Section 7(1)(b) provides abundantly that every person who does or omits to do any act for the purpose of enabling or aiding another person to commit the offense, to fall under section 7(1)(b), the accused must have done the act, or he must have omitted to do the act prior to the time that the offense was committed. So, which means that section 7(1)(b) focuses on actions that were taken or actions that were not taken before the crime was committed. Section 7.1b recognizes that when two or more people unite together to commit a crime, it takes a process. There is a string of actions. So Section 7.1b then says that he who assisted anyone to commit a crime before the crime was actually committed, he is also as guilty as that same person. So under Section 7.1b, if you knew that someone had intention to commit murder and then you handed over your cutlass to that person so the person could use it to commit the murder, even though you didn't commit the murder yourself, you are as guilty as the one who actually committed the murder. What this means is that the person who committed the murder, that is the one who acts the victim, will be liable under Section 7.1a, while you will be liable under Section 7.1b. Another illustration is where you find that two or more people, they plan together to rape a lady. Most of the times, it may be that perhaps they've been trailing the lady. Or it could also even be that they are even friends. And three guys could plan together and say, okay, you're going to invite her over and the rest. What I'm going to do is to open this door or do this, lock this, whatever. Whatever it is that you did before the actual commission of the crime of rape, you are as guilty as the one who raped the lady. And this brings to me the opinion that perhaps one can be guilty of the offense of rape even when one had not penetrated. We all know that penetration is vital when it comes to conviction on rape. But in a situation where all you did was to under Section 1b, another party to commit the offense of rape, yes, you didn't penetrate, but you will be liable under Section 7.1b. Ordinarily, in the English jurisprudence, you would have been deemed to be perhaps a principal in the second degree, or that you aided and you abetted. But like I earlier pointed out, this is not obtainable in our criminal jurisprudence, because here, both the one who did it and you that you aided, you are both seen as a principal offender. But I think it is also important to sharply point out that the mental element is also vital in this regard. Take, for example, you told me you wanted to cut the grass or something, and I handed over my cutlass to you, believing with the understanding that you're going to cut the grass, and then you went ahead to use it for another thing. I was not negligent. I never had the intention. I cannot be held liable under Section 7.1b. The one who actually committed the murder would be liable. With this, we proceed to Section 7.1c. Section 7.1c says that every person who aids another person in committing the offense is a principal offender. Every person who aids another person in committing the offense is a principal offender. The difference between Section 7.1b and Section 7.1c is as to time. The time. For 1b, it has to do with before, it precedes the commission of the crime. 1c, it happens simultaneously with the commission of the crime. So somebody is committing a crime already. Whatever you do to help the person, then you will fall under Section 7.1c. But it must be pointed out sharply that what you're going to do is not just that you did something. What you did must facilitate the commission of the offense. In the case of R versus Onweye, the court stated that to bring a person within Section 7c, there must be clear evidence that the appellant did something to facilitate the commission of the offense. So which means helping is not enough. What you have done must actually facilitate the commission of the offense. So you saw somebody, both of you planned to rape a lady, and so A was the one raping, was the one having the intercourse. Then you held B down. You C, you held B down. C would also be liable under section 71C. Why? Because what he did was simultaneous with what A did. And also what he did helped A, facilitated the commission of the offense of rape. And with this, we are then going to proceed to the gray areas between section 7B and section 7C. Two conundrum that exist between section 7B and section 7C relates to the question whether in both sections actual commission of the offense is fundamental to the conviction of the accused. And what this question really simply means is, take for example, where before the commission of the offense under section 7B, if let us say I give a man a cutlass, which I knew he was going to use to commit murder, but when he got to the scene of the event and he realized that the cutlass had become rusty and couldn't do the job, so he used a stone instead to bash the head of the victim, and the victim died. Now the question is, should I be held liable even when the instrument that I loaned him was not a facilitator or did not contribute to the commission of the offense? So supposing I give a man my gun to go use to rob or something, and then upon getting to the scene of events and they decided to use another means, should I be held liable when they had not used or when they had not employed my own contribution under section 7B? What about a situation where I am a gateman, a gatekeeper, and I decide to leave the front door opened so that my colleagues, stand in the robbery gang, not me necessarily, so that they can have access into the bank and then rob the bank. But unfortunately, they decided to use the back door, and they did commit the offense of armed robbery. Now, if eventually they are arrested, should I still be held liable for opening the front door, of course with the intent to allow them access into the bank, but that did not contribute to the commission of the offense? And so this is the question. In that particular circumstance under section 7B, does it really matter whether the aid given by the accused contributed to the commission of the offense? That is that for section 7. Can also be found with section 7C. As we all know by now that section 7C deals with any contribution that you do to facilitate the commission of the offense at the time the offense was being committed. Now the question is, what about if I should give any aid? Yes, when the offense was being committed, but the aid I gave did not contribute to the commission of the offense. The question is, should I still be held liable in this regard? Now, this is what has caused a conundrum. And so, to be able to give a logical and correct exposition on this position of the law, it is pertinent that we consider the provisions of each section, that is section 7B and 7C. Now, when we take account view of section 7B, it provides that every person who does or omits to do any act for the purpose of enabling or aiding another person to commit the offense. Now, the operative words for me is, or are rather, for the purpose of enabling. So, which then tells us that when we take a literal view of section 7B, it will appear that all what the accused needs to do is to do any act or omit any act just simply to achieve a purpose. The purpose is to aid them, to help them. It doesn't matter whether that help actually contributed to the commission of the offense, as long as the accused has done all he could do to help them, then automatically he has committed the offense. And this particular submission and position of mind would further gain credence when we consider the fact that Ordinarily, a man who was aware of the intention of another man's, who was aware of the intention of another man to commit an offense, especially a felony, has a duty under the law to make a report. So when you did not report, you have committed the offense under section 7515 of the Criminal Code. Not to now talk of when you then encouraged the commission of the offense by rendering or giving your own assistance so that they will be able to commit that offense. We must understand that under section 7b, the offense is committed before the actual commission of the offense. So it will lead to absurdity to then assume that it is the intent of the drafters of that particular code that they expected that the contribution made before the commission of the offense must always contribute, because you are committed the offense even before the offense was actually committed by the other group, who then tells us that it doesn't matter whether they used the cutlass that I gave them, and it doesn't matter whether they actually followed the front door that I opened for them, as long as I did that, and I did that with the purpose of enabling them. Of course, we know that the mental element here is also very important. So I knew what they wanted to go do, and I did my bit to help them. So it is more like, okay, I know what you guys want to go do. Now, I don't know whether you guys will be successful or you're not successful, but I have done my bit. Remember that when two or more people come together to commit an offense, like I said, it takes a process. It is a continuum of activities, and it doesn't mean that whatever everything that everyone does must always have a contribution to the commission of the offense. But one needs to quickly look at the decision in the case of Fayemi versus Attorney General. And in that case, Brett JSC, as it then was, he said, but by way of passing reference, he said that the appellant under section 7b could not be convicted under this section unless it is proved that the people who actually did the act which constituted the offense were those whom he enabled to commit it. In my article, I said that the implication of this dictum is that it suggests that actual assistance is necessary under section 7.4. It is my firm but humble view that this cannot be said to represent the correct position of the law based on two grounds. First ground is that this does not align with the express wordings of section 7b, and also secondly, it is that what Brett JSC said in that case, he made it by a passing reference, which means it was simply an obiter dictum. We know the legal relevance and significance of obiter dictum when it comes to judicial precedent. But when we consider section 7c, if you look at section 7c provides, it says that every person who aids another person in committing the offense. He didn't say who does any act or omit for the purpose of aiding. He said when you aid, which tells us that under section 7c, whatever the accused does, it must facilitate the commission of the offense. And this was also reinforced by the decision in the case of R versus Nweoye, where the court held that in order for liability to arise under section 7.1c, there must be clear evidence to prove that the aid given facilitates the commission of the offense. By and large, it would appear that the correct exposition or interpretation of 7b and 7c in light of the circumstances and events that we have raised would be that under section 7.1b, it doesn't matter whether the aid given by the accused did indeed contribute to the commission of the offense. As long as he has given the aid, then he's liable. But under section 7c, the aid given must actually facilitate the commission of the offense. But this position itself, while in my opinion it represents the correct position of the law or interpretation of 7b and 7c, I think it may lead to absurdities and may engendered some questions. Questions such as, why is it that the man who made tried to aid the commission of the offense prior to the commission of the offense liable even when what he did not contribute to the commission of the offense? But the same man who then does something when the offense is being committed, he did something also. He had the mental element to also propagate evil. But yes, you're saying that because his assistant did not contribute, then he's not liable. Then why is the one who did the assistance before liable? Additionally, if we look at a situation where where I opened the front door for my confederates to come rob the bank, but unfortunately they used the back entrance. And now if you're saying that, because I gave that help before the commission of the crime of armed robbery, I'm liable whether they use the front door or not. Absurdity may arise in a circumstance where, let us say that the police decided to charge only me. They decided not to charge the other individuals. Remember that they have the discretion to decide who to charge and who not to charge. And as the court has held in the case of Iyaro versus the state, the court stated that when it comes to the offense of aiding, it doesn't matter that you have to say that, I only aided them. I cannot be convicted when the other individuals have not been charged. It doesn't matter as long as it is shown that an offense was committed and you aided the commission of the offense, you are automatically liable. Because there are circumstances where the police may decide not to charge the other party, that is the actual offenders, based on some reasons. It may be that the actual offender is an infant, and so they may not want to charge the actual offender, and they have the discretion. So if they should charge me that I opened the front gate, all I did was to open the front gate, but they didn't use the front gate. They used the back door, so to say. They committed the offense. They have not been charged, but I have been charged, and I should now be convicted for armed robbery just by opening the front door, which they never used. This is one absurdity that can actually arise from the interpretation as much as it aligns with a literal view of 7b and 7c, and it is based on these unanswered questions and the possibility of engendering this absurdity that I submit that a distinction should not be made between 7b and 7c in the question of whether the assistant should actually contribute to the commission of the offense. If you give an assistance before the commission of the offense and it doesn't contribute and yet you are held to be liable, then the same, if another man should give his own contribution, his own aid, it doesn't matter whether it facilitates or not facilitates, he should also be held liable. Now the question would then be that what then is the jurisprudential basis for trying to punish a man who had the intention to promote a crime, but then yes, he did what he could do to promote a crime, but all he did had no contribution to the commission of the offense? In essence, why should we punish a man for trying to help some set of individuals to achieve a criminal enterprise, but then they decided not to use his help? They decided to do whatever it is that they want to do. So what is the jurisprudential basis? What is the soundness, the reason for that? Like I said in my article, I said that argument may turn on the fact that it is not, enough for a man to have a criminal intent. Yes, you may have evil intentions. You should house your evil intentions. But the moment you go ahead to manifest it, then it is the business of the law to try and curtail you. And where the law cannot contain you, the law should then punish you. So which means you should face recompense, so to say. So, but then my own grouse with this, submission would then be that if it is that you want to punish a man who had a criminal intent and then manifested it, but at the end of the day, his contribution did not contribute, or his effort was in futility because he never helped the actual offenders to commit the crime. If you want to punish him, then you must remember that he has already been punished, because there is the offense under section 515 that would be preferred against him, for he had knowledge of an intent to commit a felony and he didn't do anything to report or stop it. That is there. Additionally, when you look at it, it may even be liable for the offense of conspiracy, because the moment he agreed, that agreement itself, he agreed to foster the commission of a crime, he had committed the offense of conspiracy. So 2 offenses already. So if it is that you want to punish him, then I think those 2 suffice, not to now compound it with then saying that he is a principal offender for the actual commission of the crime, when all he did not contribute to the commission of the crime. And this is my submission. And with this, we're going to proceed to section 7D. Under section 7D, which is the liability for procuring the commission of offences under the code. Now you need to understand that the purport of section 7D is to say that if you should procure someone to commit an offense, it's more of you engage someone to commit an offense, or you contracted with someone to commit an offense, then automatically you are held liable. Under section 7D is where you decided to go ask some individuals to go assassinate another person, or you decided to meet some of your friends and ask them to beat that girl up. You understand, you are more or less contracting them to achieve your criminal objective. Will fall under section 7D. And suffice to also state that words alone or even supplying information suffices for liability. So let's say I am a gatekeeper and I happen to have knowledge of a particular sum of money that has been kept in a particular place in the bank, and all I did was to call some of my friends and I give them the information that also this is the way you can have access to the bank, this is the code to the vault, or any other piece of information that is relevant to their being able to get the money. And I never even I didn't go to the bank, I didn't do anything. All I just did was to call them, give them the information and ask that they should go and do that. I have procured them. In that regard, words or that information suffices for liability. So you see that there is procurement where an alkali, he ordered a policeman to slap an accused for contempt. You see, said he will slap him. That is procurement. And in that regard, the court said that there is liability in that particular regard. And this is what section 7D is all about. Now, for those of you who may probably be wanting to read or to read wide and have extensive knowledge on the purport of section 7 of the criminal code, I will drop the link of my article to my website, www.redibconsult. You see it down in the description down below there. So click on it, you can read it. There's even a podcast, yes, in that same particular article. So while you're reading the article, you can decide to play the podcast, or you can decide to sync what you're reading with what you can hear. I think that would also help and facilitate learning. And if it is that you just want to listen to the podcast alone, you can play the podcast. You can even go back on WhatsApp and continue to do any other thing that you're trying to do, and you still get to learn. All we are trying to do at the Already Consult is to make learning fun and enjoyable for you all. And as a result of that, we have created that website. Thank you once again. I remain Yusuf Oluwafemi Salako. And once again, please, if you have not subscribed to our channel, please do subscribe by clicking on the subscribe button down below. Please help us and then move this ministry. Thank you. Stay GD.